Okay. Hello, everyone. Welcome to the third webinar on the South-South Dialogues series that was developed by De Justicia and our colleagues from the Legal Agenda in Beirut, Lebanon. So this series is possible thanks to the support of the Ford Foundation, and it's part of the broader project that seeks to facilitate a much needed global discussion on shared human rights challenges and exchange of experience between different regions of the world. My name is Mariluz Barragán González, and I'm Deputy Director at De Justicia in Colombia, in Bogotá, Colombia. So, buenos días a nuestra audiencia hispanohablante que nos acompaña el día de hoy. Podrán ver la transmisión en español a través del Facebook Live del portal Pacifista en el link que encuentran en nuestra sesión de comentarios. Pueden dejar también sus preguntas en español y nosotros con mucho gusto la traduciremos a los panelistas. Okay, jumping back to English, in this session, closing of civic space in times of COVID-19, strategic litigation and advocacy strategies, we think to explore the different challenges that civil society face in the global south and to understand what the current impact of COVID-19 crisis is on the protection of their rights. Before introducing our panelists, I would like to welcome Melissa Avila from Melissa Draws, Wiser Together. She's joining us today and will be creating the graphic summary of our conversation. This will be compiling the most important points discussed and will be available for download in the following days. So, Melissa, can you please show us your empty board so the audience can see how you process a start?
Thank you, Mariluz. But it says host has disabled the attendee screen sharing. Can you please allow me?
Yeah, sure. So I think we are struggling with that. So we can continue, and then at the end of the process, you can share the final the final row. So
okay, thank you.
Thank you, Melissa. Now I would like to welcome our three panelists. Two of them from the MENA region and the other from LATAM. So all of them experts in the field of strategic litigation and judicial system. They will share their reflections as advocates of human rights from different parts of the world. The first person I would like to introduce is Nizar Saghieh. So Nizar is a lawyer, co-founder, and executive director of the Legal Agenda since 2011. He has researched and written extensively on a wide range of legal topics, including war memories, freedom of expression, and vulnerable groups. He has also pursued strategic litigation in relation to the complex social issues such as arbitrary detentions of refugees and disappeared in Lebanon's civil war. Also, is joining us today Carolina Villadiego. Carolina is a lawyer, a specialist in judicial systems and its connection with human rights in Latin America. She has developed various advocacy strategies in this field. Her publication includes several articles such as the multi-thematic and diverse reforms of justice in Latin America and non-criminal justice systems in Latin America. Currently, she is legal advisor for Latin America of the International Commission of the Jurists. She is also part of the board of director of De Justicia. Welcome, Carolina. So finally, from Jordan, we have Linda Alkalash. Linda is the executive director of Tanken for Legal Aid and Human Rights since 2007. So she leads a team of lawyers, researchers, and advocates to combat human trafficking. So through years, she has also represented Tanken in number of national, regional, and international conferences and events that focus on labor issues, migrant workers and migration, legal aid, and human trafficking. Welcome again, Nizar, Carolina, and Linda. Thank you, all of you, for your willingness to share with your time and expertise with us for what I'm pretty sure will be a very fruitful and interesting conversation. So, to start, I would like to provide an overview of some experience of strategic litigation and advocacy in MENA and LATAM regions in the context of COVID-19. So, global society, governments, communities, and individuals are being tested by the pandemic. So, respect for human rights, including civil, political, economic, and social rights, will be fundamental to success the public health response. Even though the COVID-19 is generating suffering and damage in every region, it has disparate negative impact in the global South countries. So, in terms of civil and political rights, governments have been taking exceptional decisions. Emergency measures may well be needed to respond to this public health emergency, but an emergency situation is not an excuse to disregard human rights obligations. All measures must be necessary and proportional. With this premise, that has not been taken into consideration in the most governments, some countries have taken measures to impose a restriction of media freedoms and freedom of expression. With the excuse of misinformation, these measures could be easily applied to any criticism. In some countries, we have already seen reports of journalists being penalized for reporting the lack of masks, health working for denouncing lack protection, and ordinary people arrested for social media posting about the pandemic. According to the UN High Commissioner of Human Rights, Michelle Bachelet, arrest for expressing discontent or allegedly spread false information through the press or social media have been reported in Bangladesh, Cambodia, China, India, Indonesia, Malaysia, Nepal, Philippines, Sri Lanka, Thailand, and Vietnam. So actually, just yesterday, in that sense, we have concerning news here in Colombia because people now who spread fake news about the pandemic situation could be penalized for terrorism. So that seems that we are joining this political trend. So on the other hand, regarding to economic and social rights, in the North global country, fault lines in access to healthcare, labor rights and social protection and living spaces and indignity are suddenly very visible. Like in the United States, with the disproportional impact of the negative effects of the pandemic in African Americans and Latino people. However, in the South global countries, where a large portion of the population may rely on daily income to survive, the current impact is far greater. So the millions of people who have little access to health care or who, by necessity, live in a crowded condition with poor sanitation or no safety net, no clean water, will suffer most. So they are less likely to be able to protect themselves from the virus. In this context, the pandemic is likely to create even wider inequalities. So extensive economic and social measures have been taken in some countries to face the negative effects of the pandemic and minimize the further growth of inequalities. Some others have explored new financial mechanisms to fund global solidarity. For example, the African Development Bank raised the world's largest social bond, 3 million US dollar fund to assist African government to expand access to health and the other essential services and goods. Despite those efforts, most of the global countries in the South have less capacity to mitigate the economic and social impacts of the pandemic. Um, After times of social economic stress, disputes and litigation significantly increased. The COVID-19 pandemic, with its unprecedented impact on every single phase of life, is likely to give a rise to a tsunami of disputes. So, South global countries could soon face a wave of lawsuits from multinational corporations claiming compensation for measures introduced to protect people from the COVID-19. But it seems to be an upcoming problem. So, what has not been delayed are urgent litigation and advocacy actions related to the protection of human rights. As COVID-19 expanded, the reaction of the mobilized civil society were also being activated. So the development of the novel advocacy strategies and litigation have been common to control the measures taken by the governments in the global south. For example, in Zimbabwe, doctors have taken to government to the court over its failure to provide them protective gear during the coronavirus pandemic. So the association has demanded that the government must urgently provide personal protective equipment for all medical practitioners in Zimbabwe. Similarly, a few days ago here in Colombia, the constitutional judge ruled in favor of a group of doctors who work in one of the poorest regions of the country. In this case, for litigation, the national government was pushed to grant the necessary biosecurity equipment to the plaintiff. So this is just in order that the plaintiffs could carry out their work safely. So also after some human rights advocacy, so these Asian nations are joining the growing list of countries to release prisoners from overcrowded jails. So for example, in Indonesia, start freeing some 30,000 prisoners, that is about 10% of the prison population because of the risk of coronavirus in early April. So also in Lebanon, as a consequence of advocacy action, the national government took a set of measures to protect migrants, domestic workers during the COVID-19 pandemic. So the authorities ensure that migrant domestic workers are protected for exploitative working conditions during lockdown. So, and that means all domestic workers, including the undocumented. So now they have access to health care during the pandemic. So in Colombia, even some cases that did not start on occasion of the COVID-19, the judicial decisions were influenced by the context, such as the case of protection of social leaders. So just to contextualize the subject, Colombia is one of the most dangerous countries for human rights defenders. In the mentioned case, the judge ordered that Colombian government to protect must protect human rights defender without officials being able to excuse themselves in the pandemic for not complying. So the main reason judge put forward was that human rights are not suspended in the states of emergency for the pandemic. So I'm leaving the context up to this point because the idea is that our panelists help us to understand better the situation of strategic litigation and advocacy on human rights in the Middle East and Latin America regions, and why not, to propose us some strategies to guarantee the protection of the rights in the current context. So we invite our audience to leave any question you may have for our panelists in the chat, in English or in Spanish. So, and afterwards we will have a question and or an answer sections. So to start the discussion, I would like to invite Nizar first to share with us a brief context of strategic litigation and advocacy on human rights patterns in the MENA region. Nizar, the floor is yours. Thank you.
Thank you, Mariluz. So I am from Legal Agenda. Legal Agenda is a law and society project And we focus on judiciary, and we are involved with many strategic litigation on matters of social and economic rights and others. What I would like to stress on is a distinction to which we are very attached, which is to make a distinction always between what is popular strategic litigation and unpopular strategic litigation. Or if you want, having litigating for popular issues or unpopular issues. What is popular? So when the majority is approving a right and still this right is not recognized or is not respected, so you go to courts in order to force the authorities to grant this right. But so here, I mean, and what is unpopular is when the majority disapproves this right you are fighting for, like, for example, for migrants in general, refugees, or even in our region, LGBT, sometimes women's rights, and so on. And we have two different strategies, completely different. And we know very well that this the difference between two is not stable. So sometimes what is popular might become unpopular, and what is unpopular might become popular. I explain. So when we were fighting for freedoms, for example, or civic rights, or I mean individual rights, individual freedoms, it was like in general a popular issue because everybody identifies him or herself with this. So now with Corona, this issue, when it's becoming like a balance between health and freedom, so it becomes sometimes unpopular. So when we talk about a curfew, if this curfew is necessary or proportional, so the instinctive opinion is quite against. I mean, and they are saying, oh, you are trying to endanger society by defending these freedoms, while we are trying to defend legality and that any measure is proportional. So we had these problems recently with curfews and so on. And also another example of what is unpopular, which become popular, is women's rights, if you want, in some areas, especially when they are victims of violence. So a few years ago, it was too unpopular. Now it becomes like mainstream that we refuse this violence against women and so on. And you know very well that even in Corona times, I mean, we had many, many issues with domestic violence and so on. So of course, I mean, when we are handling a popular strategic litigation or unpopular, we have two different set of tools and instruments and strategies. So it's not the same, it's totally different. And for example, when it's popular, I mean, we try to mobilize the public opinion. We do everything through media, and the aim is to show that what is done, the practice or whatever is illegal. So our main argument is legal and is law, and how to show that the practice is abusive, illegal. Sometimes we are shaming, and we are asking the judge always to be loyal to the majority, loyal to society, I mean. And to face the power and the powerful people. But when and our style is denouncing, shaming, whatever you want. When we are tackling a non-popular issue through strategic litigation, our strategy is different. Is less using the law in order to impose what is legal. It's more to convince through law, but also through social research. So it becomes like if we are not only, we are making much less recourse to media, but much more recourse to social research, because we need more arguments in order to rationalize the debate, to rationalize the debate over Corona, to rationalize the debate over any other issue about homosexuality or about migrants, and so on. So the strategy litigation becomes not a mobilization tool, but in order to rationalize and how to make that in such ways that court becomes a platform to rationalize the debate over the issue we are working on. And of course, the judge here, we don't tell the judge you have to face the most powerful. You have to face here the a priori, the preconceived ideas, and you have to think out of the box and always to make recourse to what is rational and what is not. And our style is different. It's not shaming, it's not denouncing. It's a more social thoughts and trying to convince, trying to bring the adverse idea to discuss with us, to try to give their arguments, and then we exchange arguments through the court and so on. So that's why, I mean, when we are working on unpopular issues like now, it is the case when we work on migrants who are deported, who are forced to deport, or who are fired because we don't need them anymore during Corona times, because we don't have enough resources. So the people that we exploited for many years now, we want to terminate the contract with them because we don't want to pay. We are no more able to pay. And that becomes everybody now during Corona times, after the productivity of people becomes much less. I mean, and the revenues become much less. Everybody can say, I have no more money, so I want to terminate with migrants. So we have this very big issue of migrants fired. And when we say migrants, most of them in Lebanon are domestic workers. So living inside the house where they are working, so they are fired. That means, subject to deportation, of course. So here it's very difficult now during Corona time to find a way to litigate, because most courts are not operating now during Corona times, and they stopped. So what we need to develop and what we are developing now is how to have this cross-border litigation. And this is one of the most, we are trying to develop this. The cross-border deportation, that means litigation, sorry, that means that this litigation will start once the migrants are deported. So after they are deported, we get power of attorney and we start litigating. We thought many years ago that it might be the most effective litigation in our country because of because the power, the relation is so much unbalanced, and the employer is much more powerful than the employee, and then you have all this preconceived idea and so. But now with, our main challenge was to convince judges how to use technology and online, like we are doing now, to hear the story of domestic workers, the narrative of domestic workers, because we had, because of the system in Lebanon, which is very complicated, we don't have time to explain, is the sponsorship system. So deportation becomes always the solution once there is any litigation between the employer and the employee. And so we don't have any narrative in courts about the miseries, about the abuses, about the trafficking, forced labor. And we needed absolutely to develop this cross-border litigation. And now, the problem becomes much bigger for migrants. They are deported in big number. But still, I mean, we have an opportunity now because thanks to Corona, for the first time now we have online interrogation with people who are accused, people who are prosecuted for common reasons and for, I mean, inside Lebanon even, because the judge does not want to risk contamination. So they are doing the interrogation through online. So now we have this opportunity, and the Ministry of Justice is setting up this. So now all we are working on regarding migrants is this kind of developing the cross-border litigation, and we think that it might offer us much more narrative about it. I have two other ideas and then I will stop. And of course, I will answer any question after. So now the main work was done on the pre-trial arrest because during Corona times, I mean, the pre-trial arrest is very, very common in Lebanon, very frequent. More than 50% of people who are in jail are in pre-trial arrest. And before judges, I can talk about Tunisia also. They had this habit that each time there is very strong evidence that he committed a crime, we arrest him. So during Corona times, I mean, there were lots of discourse about it to redefine the pre-trial arrest conditions and to reduce the number of arrestation during the trial. And lots of people were freed, of course, with Corona. And we start to talk about proportionality and necessity of arresting somebody during this time. So it was another opportunity also to develop this discourse about who should be arrested during his trial and so on. The last point I would say, I mean, I feel that there is a big challenge regarding the social and economic rights during this crisis, because as you know now, I mean, resources, revenues are much less. In Lebanon, we have a very, very big economic problems. It's not very far from what's happening in Venezuela, I think, with bankruptcy and so on. So what kind of social and economic rights can you really defend and which might have a chance during such period, and especially with Corona and so on? And I am afraid that we are facing a period where it will be very difficult to defend such rights, and that it might be because, I mean, it's not that we have resources and we don't know how to allocate them, but we don't have any more resources, and we need maybe to bring more resources from those who have. And this makes that maybe the social rights will be more in the political arena than in the legal one. So I finish with this note, and of course I can answer all the questions afterwards. Thank you.
Thank you so much, Nizar. So I want to stress some points about your presentation. It is called my attention that you already identify some positive effects of human rights of this situation, Corona in Corona times. Those issues that were unpopular before and now with the coronavirus become popular, like women rights using digital tools in justice, and talk about necessity and proportional issues. So, but also you talk about the basically you are facing so many challenges because of the access to justice now is kind of limited, right? So because most of the judicial offices are closed. With that, I gonna give the floor to Carolina, who is gonna explain us a little bit about what are the challenges that we are facing in this part of the world and about the judicial systems and what are the measures that have been taken to overcome this, like the situation that we are facing now. So Carolina, the floor is yours.
Thank you, Mariluz. Good morning and good afternoon to everyone, and thanks to the Justicia and Legal Agenda for inviting me to participate in this webinar. My intervention will focus on 3 different issues. First, I will provide an overview on the general measures that were adopted by judiciaries in South American countries during the pandemic. Then I will present an overview of the main concerns regarding those measures. And at last, I will address some points of action in advocacy and litigation regarding the need to strengthen access to justice during the pandemic. So with that, I'll move to the first point, which is a general overview of the measures adopted by judiciaries. So in general terms, for our public, in South America, most of South America, in early March, as coronavirus cases were confirmed, most governments adopted general measures, as in every other country in the world, consisting of isolation, social distancing, and so on. So with that in mind, judiciaries in South America also adopted several measures with the aim to provide access to justice but protect people's health during the process too. So as a result, and in general terms, ICJ with other NGOs did an overall review on the general measures adopted by judiciaries, and there were, in general terms, 4 general measures adopted by most judiciaries in South America. The first general measure was to postpone proceedings in ordinary matters. So that's why many proceedings in civil cases, labor cases, etc., were postponed. Second, the judiciaries adopted measures where they allowed judges and other judiciaries personnel to work remotely. So that's also to say that judges and other personnel are working from their homes or remote, and they are advancing in some cases. The third general measure that was adopted was to provide some digital justice or virtual justice measures, and that includes several specific measures. I would just highlight, for example, being able to present remedies or reads by email, or doing some hearings by video conferencing. And the fourth general measure that was adopted by judiciaries was to provide and continuing to provide access to justice in specific measures that were considered urgent or essential. It is not necessarily clear the definition of urgent and essential, and there are differences between each country, but basically we could identify at least 4 types of cases that were considered in this category. Remedies that guarantee fundamental rights, so basically habeas corpus or constitutional actions that protect fundamental rights, as for example in Colombia, tutela or amparo in other countries of this region. The second measure was, for example, that the judiciary allowed proceedings that include judicial review of deprivation of liberty. So, for example, control of detentions, control of apprehension, so on. Then there are also cases of domestic violence and protecting measures on cases of domestic violence. Other urgent matters in specific cases, for example, that involve child parenting support, and judicial review of governmental measures adopted during emergency states, this in some countries. So those are like the basic general measures that were adopted by judiciaries during the pandemic. Almost 3 months have passed since these measures were adopted. And what is the status now in South America? So this changes between each country and between each reality, but in general terms, most of the measures have been extended in time, as the government has also extended in time isolation and distance and social distancing measures. Some of the measures have also been reviewed by judiciaries, so meaning that they have, for example, make it a wider mandate on the extension of access to justice in specific cases. So now many judiciaries have more cases that they are actually receiving writs and remedies. And they're also, some of them are analyzing or deciding on how to move on in a middle term plan with the pandemic. So with this in mind, I will turn now to the second part of my presentation, that is about the main concerns of how these measures have affected access to justice and what do we need to do now, because there's no strategic litigation with courts closed. So what are the main concerns? And as I said, also this is part of a joint analysis that we made with other NGOs in this region. I will highlight for this presentation 5 main concerns. First, there has been a reduced access to justice in all countries of South America during this time of the pandemic. And this has special effects on persons that are under vulnerable conditions, as for example, persons that are in prison or that their trial is pending, or migrants that need their fundamental rights to be protected immediately, and so on. So as it has been 3 months, it is important that judiciaries come up with a clear and transparent plan on how are they going to provide access to justice in the immediate term and also in a middle term plan. The second main concern, is that there has been lack of a comprehensive and public information regarding all the measures adopted by judiciaries. There has been, in some countries, more publicity than in others. But in general terms, what is important to mention here is that there's lack of real information about how are the measures adopted by judiciaries worked in the past, how are they working now, and how are they working in the specific parts of each country. So as some of them are general measures for the country, we also want to know specifics on how this affects access to justice in specific regions in each country. The third type of concerns that have arisen with these measures of the judiciary are problems that came up with the virtual or digital justice. So as this is a very important tool, there are 2 main concerns here. One is that there is a digital gap also for persons in a country, and that gap is due to lack of connectivity, lack to access to computers, to internet, and even if there is connectivity, internet services are expensive, so not everyone has access to it. And on that point, the issue is that if judiciaries are providing a lot of access to justice through digital measures, this is generating a disproportionate affection on people that do not have access to internet or access to these mechanisms. And then there's a second part of concerns regarding digital justice, which is that we need to analyze further the impact of video conferences in specific hearings, for example, on due process guarantees and right to counseling, especially in criminal cases, especially for persons that are detained. With that, I'll move to the 4th set of concerns, which is that one of the other set of concerns is that there is a need to address if there has been real judicial review of governmental measures. So as governments have adopted a lot of measures to fight against the pandemic, judicial control is important, and in some countries there has been more judicial review than in others, and even in a country like Colombia, where there's some judicial review, there's also differences on what are, if they have been able to control all governmental measures in time. And the 5 type of concerns that I will raise is that there's also a lack of information about the real conditions of judges and judicial personnel that are working remotely. So as the judiciary physically closed, but the judges and judges homes or not, if they do have access to computers or not, if there's if they are also caring for children, and what is the impact on that on the work, etc. So those are like the 5 main concerns that I wanted to highlight for this presentation. And with that, I will turn to the last part of my presentation, which are some points of actions on advocacy and litigation regarding access to justice. So on the advocacy side, I will stress that judiciaries need to explain and come up with a clear and transparent plan on how they're going to guarantee access to justice, not only in urgent or essential matters, but in all matters, and how are they really going to put a plan to provide this kind of access to justice, considering also the need to protect health for persons that attend proceedings and also for judges' personnel. And I think almost 3 months from having spread this pandemic in this region, this is a mass needed advocacy plan now for advocates and human rights defenders to advocate for the judiciaries to do this. And on the litigation side, I will stress that we need to be really strong on having the judicial review of governmental measures and measures that have been adopted during the pandemic. Also, to be on top of knowing if there is really access to justice for persons that are under vulnerable conditions, such as persons that are deprived from liberty or with lack of access to health, to water, to housing, etc. And finally, I will say that as access to justice needs to be guaranteed to everyone, if judiciary is going to move to a more digital approach, there is need for us to litigate in the need for having access to justice, access to internet in an equality condition. So there's no point of providing too much access to justice by internet if persons do not have access to internet, or if internet services are very expensive. So with that, I will close my presentations. I thank you all, and I am also available for questions.
Thank you so much, Carolina. So again, we invite our audience to leave any questions you may have for our panelists in the chat in English or in Spanish, and afterwards we will have a question and answer session. So cualquier pregunta que ustedes puedan tener para nuestros panelistas, para Carolina, que acaba de hacer una interesantísima presentación, la pueden dejar en nuestro chat y nosotros con muchísimo gusto la traduciremos para nuestros panelistas al final de la sesión de preguntas y respuestas. So, thank you so much again, Carolina. So now I would like to jump back to the MENA region for giving the floor to Linda. So she will present us how all those challenges are experienced on one of the issues of greatest social tensions in the region. This is migration and human trafficking. So Linda is gonna explain us how they are facing the challenges that we already explained to us, Nizar, but also we have so many points in common with what happened in the MENA and Latin region that such as already Carolina just explained us. So Linda, the floor is yours. Thank you so much for being here today. Linda, your microphone is again. Is it still to run, please?
Yes, now
okay.
it's okay.
Okay.
Yes,
yeah.
I'm very happy to be here today to talk about this issue. In general, Tamkeen work with the labor, with the issue regarding to labor migrants and countering counter human trafficking. And all of us know about the situation of migrant workers in every place, not only in Jordan or in near region, in all the world. Migrants always suffering from discrimination and other. In Jordan, maybe if we are talking about what happened through combating pandemic, in the beginning, many people were released from detention or from prison, but the migrants still there. But in the beginning of the situation of this situation in March, last March, the government reactivate the law. Defense law to deal with this issue. Defense law gives the government right to disable all legislation. So through this period, we have almost only the order that issued by the government. Most of the order, the main one about freedom of movement, that prevent people to go out of the houses regardless anything. This prevent people to go to purchase the food, only the food. And we have, of course, migrant workers, especially migrants in irregular situation, especially domestic workers that work as freelancer or in irregular situation, that they need help, but nobody provide them with humanitarian assistance, or the assistance only for Jordanian. Even the workers in regular situation, when the government issued the defense orders, they have number 9, especially number 9. It has many programs about social protection, but with excluding migrants. In spite, migrants contribute in social security like Jordanian and other. We noted through this period that maybe absence for the justice in general. And nobody can go to file complaint, but accused people can go to the court. But in this case, we find absence of lawyer, so they missed their rights in defense. And for example, I remember case for Bangladeshi. He is journalist here in Jordan. I think somebody from maybe his country filed complaint against him because he wrote something about the role of mission in Jordan to help the Bangladeshi people, and he was arrested, and lawyer couldn't go to him because it's not allowed for anybody to go outside, and no translator through this judgment. And the deportation issued against him, but he stay in the jail till now because no flag in this way. So we are talking about kind of justice absence all this period, even when we have now particularly that the ban left, but still I think the justice in ban. Beside, very important issue regarding to electronic litigation or litigation online, I think maybe Jordan and any country not ready for this. So we have problem regarding to this issue. Through the pandemic, we find that many workers that they fight it from their jobs, and especially migrant workers. Sometime we found 1,200 workers at the same day. They fight from their work, and also legislation base. We found that the government issued in the beginning of this month, or at the end of last month, in May 30, they issued order number, note number 7. This note regarding to order number 6. This note exclude migrant workers from this note, from the protection of them. In spite this note, it's also it's not good for Jordanian and non-Jordanian for labor issue. Anyway, I think it's very important to work in the issue regarding to social and economic rights that violated through this period by the government, by the employer, and we don't have this balance between employers and employees. Anyway, till now, it's very important to have this a real judgment. Till now, yani for example, we try to file complaint from the beginning of this week, but we fail because the public prosecutor, they refuse to receive any complaint. So till now, judgment it's stopped and nobody can go. Regarding to strategic litigation, which is very important, well, I think it's very important after reactivation the defense law, as we have many cases regarding to this, many cases about the worker that they lost their jobs, they lost their salary, about the deduction from the salaries, about the annual leaves and other. In the case of domestic workers, we found through pandemic that the domestic workers inside household, they face violation by the employer, maybe because of all the family members inside the house for all the day, and the stress because they are inside the house, they couldn't go outside. They reflect this stress on the domestic workers. Regarding to cross-border litigation, I think it's very important, and we used to make this before. Sorry. In many cases, the workers or migrants, they deported, but we continue in this cases. But in the issue of human trafficking, which is very important, we have to have this relationship between countries of origin and countries of destination in general. And also regarding to human trafficking, we found through pandemic, we found that no protection for victims of trafficking. The shelters closed in front of them, so no place to put them inside. Nobody received them. We faced many cases, and it was very difficult to deal with them. Not allow for us to go outside, not allow for shelters to receive any victims. And we are talking about women in crisis, women face violence, but nobody received them, even the embassies, because it was not allowed for anybody to go outside or to receive without corona test. And even with corona test, they didn't receive this. And regarding to access to health, it was no discrimination regarding to this between migrants and Jordanian, or Jordanian and non-Jordanian, but there is some problem regarding to access to, it was very good for the government that they deal with access to health regarding to corona, but access to health regarding to other, no. We found that many people, they couldn't go to the hospital, and some of them died, and they face many problems regarding to this. So I think it's very important issue to focus on. This is the issue now. Maybe I can complete after. Sorry.
Sorry, Lida, thank you so much for your presentation. So if you agree, we're gonna move on to the question and answer sessions. So I'm gonna present some questions that we already have for Nizar, Carolina, and Lida. So I would like to start with Nizar. So you mentioned that we currently cannot only rely on litigation, and we should think about the political world and society, especially in countries where there is a crisis like Lebanon and Venezuela, right? Can you tell us a little bit more about how our role of us of as litigators and advocates and social society actors will change in front of this context of Corona times? And also, you mentioned that using digital tools for judicial process is a good outcome of these Corona times. So, because of the pandemic, the start those online hearings that did not happen before, or before are not that common. So, um, however, Linda just said that no country in the region is ready to this step. So, according to your understanding and your perspective, how does these digital tools affects the access to justice in Lebanon? Those are the first two questions for Nizar. For Carolina, so you talk about the digital gap and inequality. So, what is one of the great problem or concern that has become evident in the pandemic? So, in Latin America, is not having access to internet the same as not having access to justice? What measures have or should be implemented to guarantee the most equitable access to justice now in Latin America, according to your presentation? And the final question for Linda. So, Linda, in your presentation, you expose us all the concerns that you have in the Corona times in Jordan about migrants and human trafficking. But also, we want to ask you now if maybe are there any positive elements that we can retain from the COVID crisis in Jordan or in the region? And what are the measures that we can benefit from in the future? So, with those questions, I'm gonna give the floor to Nizar to answer the first two ones. Nizar?
Thank you very much, Mary. So, I mean, regarding the digital justice, for many countries, and Lebanon is one of them, it's a first experience. In inquiring, interrogating through online. And of course that brings lots of problems. Carolina talks about some of those problems about discrimination, and even it's not given to all judges to do this because it depends on courts, on the regional. Where the courts are. In Tunisia and Morocco, in our region, they made a regulation about it. And in Tunisia, they made a regulation for all times, not only for Corona. So it was in the law. And it is in order to protect the right to defense and to make in such sort that, because sometimes you are interrogating an accused person where he is at the police station where he was maybe tortured, but he can no more talk about the torture because he is there. So you need lots of guarantees to be done. But what I said in fact is that for us, we were asking for digital justice for years now regarding the migrants. Because for us, it was very, very difficult to have a real strategic litigation where the domestic workers or the migrants, the abused migrants, might come to talk about the abuses and to have this narrative inside courts, because we believe in the importance of this narrative because they were deported. Sometimes they were arrested, interrogated, deported, even before the file arrives to judiciary. So, and then the trial is made in their absence. And most sentences are done in absentia. So what we are claiming for was this kind of digital justice for the cases where it becomes really impossible for those persons to come to court. I mean, and we thought that, I mean, through the corona, I mean, it's an opportunity. I mean, we were talking about lots of challenges, about lots of negative things on our work, but I mean, in this respect, I mean, it was something, an opportunity for us to say, now the cross-border interrogation became possible. So now the judge is invited to hear those domestic workers who are talking about trafficking, forced labor, or abuses, or so on. Because we know now there is a big number of people fired without paying them any salary for months. I mean, and they can come from very poor countries in Asia and Africa. So that's what I said about digital and why it might be used as an opportunity. Of course, courts even WhatsApp meeting or what. So there are very different tools to make this. And till now, Lebanon is not really regulated. So there is lots of case per case and initiative done by judges. So of course, we are going now to work on how to regulate this and to advocate for that. Regarding the second question, about what can be done in countries in Lebanon or Venezuela, which are really subject to big economic problems. I mean, I don't know. I mean, it's now you have a big number also of people who are fired from their works, or at least where the salaries became half or reduced to half, or even to the third. And you have the national currency, which is losing its value and its power. And we have a problem with banks who are no more paying the depositors without having any law regulating this. So all this is bringing lots of problems, and you have the tenants and the land owners. So we have many types of litigation between different categories of people, and everybody is ready to fight against anybody, employee against employer, tenants against landlords, and so on. So it's becoming, it opened door to all kinds of litigations with a state which is really absent of all social issues and leaving, to society to deal with its problems. I mean, like they know. So, I mean, so what can be done? I mean, to make a legal aid for all those people is quite impossible for our organization. The Bar Association now is quite, I mean, recently they are more involved in those social issues. So, but I mean, still now they keep selecting what they want to do, but not really social rights. We think that it's time to have collective cases. I mean, to select our strategy litigation in very smart way in order to have something against a which might have not a effect only between two people, but also to have an effect against one sector. For example, the banks. I mean, we go and sue the association of banks, or we do this. So we are trying to have a strategy litigation with using association and syndicates and trade unions against collective banks. That we did, for example, regarding now the banks with the consumers the association of many association of consumers making cases against the association of banks in order to get what is really needed for because I mean the banks were not paying the salaries and so on. The salaries which were deposited in the bank. So that's what we are trying to do now. And but of course, I mean, how to select, it's a big story. And maybe I can stop here.
Thank you so much, Nizar. Carolina?
Thank you, Mariluz. Thank you for the questions. Well, problems of access to justice are wider than the digital gap regarding access to justice in this particular time of the pandemic. So, I mean, we had way before coronavirus problems regarding access to justice that goes to the costs of the proceedings or having a lawyer, what the proceeding takes too long to have a resolution and real access to the courts, etc. So that's it's a wider problem that we had in Latin America. With this specific pandemic, we face several challenges. One is that judiciaries have been doing an important effort, most of them trying to provide access to justice during this special time. And so digital justice or virtual mechanisms to provide access to justice has been one of the most important tools to address this. And that is very welcome because the justice systems previously had some of them had lack of technology, and it's important to use technology. I think what I want to stress is that with technology and with more virtual access to justice, we need to do some reflections on specific things. There are many things, but I wanted to stress two in this particular conversation. One is that we cannot forget that internet services are not really not everyone has access to internet services. Sometimes it is not because of lack of connectivity, but because of lack of payment. Because internet services are somehow expensive. So this cannot be overseen, and we need to focus on that. There's also a matter of if we really know how to deal with this technology. If does persons know how to address this, how to present a remedy by internet, how to use internet, and also if judicial personnel know how to deal with this technology. So it's a complete reflection on all of it. And then I also think that we need to analyze the specifics on other situations as due process guarantees, right to counseling, to effective counseling. There is a reason as to why there are some hearings that are inherently to be face by face, as for example, detention controls, because judges need to control if there was no torture on police stations. So there are some hearings that are inherently have to be done in a face by face. And there are other safeguards on due process. So that is why I think this conversation it's needed, and we need to come up with analysis and suggestions and recommendations so we can all strengthen access to justice in reality. I will leave it there.
Thank you so much, Carolina. Linda, the floor is yours.
Yes. I think it was, maybe I forget to mention this very important issue regarding to discrimination through the pandemic or through the curfews in Jordan. We found that we had quarantine in 5-star hotel in the beginning of from March 15 till now. We didn't find any discrimination between domestic worker that came to Jordan at that time and Jordania and other. They both each of them in a private room in 5-star hotel. And also we didn't find any discrimination in access to health regarding to corona in the hospital regarding to domestic workers, as we had, I think, 3 domestic workers that they get this disease. Anyway, I think in the future, it's very important to work on the issue regarding to defense law and the results of defense law. What happened regarding to this by against migrants and Jordanian at the same time, because this harms Jordanian and non-Jordanian, this law, and because as I mentioned in the beginning, it's disable all legislation. It's give only the government to put all legislation still now, and we found many regarding to this. Third, I think it's very important to have migration policy, to have registration for all the migrants in our countries, migrants in formal situation and migrants in informal situation, and also the relationship between non-Jordanian and their embassies and their countries, and also human trafficking. All of us know that human trafficking, if we are talking about combating human trafficking, we are talking about prevention, protection, prosecution. So we missed the issue regarding to protection, how to protect the victims of trafficking, that it was absent in all this period. Anyway, we issued 12 reports about the situation under curfew from March 18 till yesterday, about the sectors, about the nationality, about everything regarding this. I think we can use this in litigation and to build cases regarding to this. Thank you.
Thank you so much, Linda. So finally, just to wrap it up, I have a final question for you all three. So this is actually an open question. So I want to invite our 3 panelists to share with us maybe a final reflections that you may want our audience to keep in mind at the end of this conversation. So if you are able to identify those 1, 2, 3 key points that you want our audience to keep in mind, so please share with us in 31 minutes now. So Nizar, we're gonna start with you, then Carolina, and then Linda.
Yeah, I mean, I think that we are, all of us in the world, somehow going to have less liberties, and I mean, so we have to be ready for when we tackle any freedoms of or liberties or civic liberties. I mean, that it might look as an unpopular case, so we have to be ready for unpopular strategic litigation, and that should be the one. Yeah, it becomes much more difficult to talk about necessity, proportionality, when a society is subject to fear, and they feel that their life is endangered and so on. So again, I mean, for those who are working on litigation, who believe in such litigation, in the use of law in order to promote rights and so on, I think really in the coming period we might have to think more about how to what kind of strategy when we are facing an unpopular case. I mean, I mean, this is the most important point, I think, in these Corona times.
Thank you so much, Nizar. Carolina?
Thank you. I will strengthen three main ideas. First, access to justice is fundamental in a democracy, especially during the pandemic. It's more fundamental indeed, so it has to be guaranteed. Second idea is that proceedings cannot be postponed and suspended, and that comes to the third idea, which is that judiciaries need to come with a plan that is public and transparent, that tell the people how are they going to guarantee access to justice or to provide justice services during this time, and that they really also think about the specific guarantees that can be that need to be guaranteed also in the proceedings, as due process, right to counseling, and so on. So that would be my three ideas.
Thank you so much, Carolina. Linda?
I think it's very important to talk about more spaces for CSOs that we found many difficulties last period, not only in Jordan, but I think in many places. Second, it's very important also to find some cases to work on, if we are talking about migrant work in both countries of origin and countries of destinations. Well, I think we will face a difficult period in coming months regarding to especially migration, regarding to repatriation, regarding to lost their jobs. We are hearing about what happened in Gulf states, for example, and of course in Jordan and other countries regarding to this. It's very important to be ready about this by reports, by litigation, and to complete each other as organization roles. Yes, thank you.
Thank you so much, Linda. So with those interesting conclusion, we are closing our conversation. So thank you once again for our to our wonderful panelists, Nizar, Carolina, and Linda, for sharing your reflection with us today. So we are pretty sure that they spark many future conversation. I was honored to moderate this incredible panel today. Thank you also to everyone who watched this transmission today. Now I want to give the floor to Melissa. Melissa, would you please show us the graphic you made? I think that you are available to share the screen with us now.
Hello. Well, this is part of I'm doing right now. I'm gonna finish later to put some more drawings. One important thing that I heard in all of the talk was the important part of having access to justice, and that migration policy is needed, and the imbalance between employees and employers.
Okay. This image that just Melissa showed us will be available for download from the social networks in the following days. So thank you, Melissa, for this wonderful graphic memories as usual. So
thank you.
I also want to thank to the Justicia and the Legal Agenda teams for making this possible, especially to our communications and international teams working behind the scenes before and during these 3 sessions. So this is our third and last webinar of the South-South Dialogues series. If you were not able to follow the last sessions and you are interested in our previous dialogue, please visit our YouTube channel and you will find them records. So thank you again to all our 3 panelists. Thank you, Melissa. Also, thank you, you all. Take care and goodbye.
Thank you.